Hello and welcome to the second episode of Mayor Brown's video series at the Crossroads, CFTC and DOJ Enforcement. My name is Matt Kluchenek, a partner at Mayor Brown, a member of Mayor Brown's Litigation and Dispute Resolution Group, and I'm joined again today by my partner, Glen Kopp, a former federal prosecutor out of the Southern District of New York. Each week, as you may know, our goal is to bring to you to cover a topic on CFTC and DOJ enforcement. Glenn?
Thanks, Matt. And so as you mentioned, a foundational issue for us, and the reason why we're here is to talk about coordinated investigative efforts, enforcement efforts by the DOJ and the CFTC in the commodities and derivatives markets. And when we talk about that issue, we talk sort of colloquially about coordinated efforts. But there is actually an important distinction to be made in certain contexts between joint investigations by the CFTC and the DOJ and parallel investigations by the DOJ and CFTC. Matt, can you sort of kick us off with a little bit of why that's important and how that's come up recently in an important case in our space?
Sure, thanks, Glenn. So it sounds like a relatively technical distinction, joint versus parallel, but as we've seen, it can have some really, really large implications. And earlier this year, Judge Lee out of the Northern District of Illinois in U.S. versus Bases and Pacilio highlighted how too much coordination can actually result in a discovery obligation in favor of the defendants upon the government. So in that particular case, that involved an investigation by the CFTC and the DOJ of a number of precious metals traders. A number of those traders were indicted, not all of them, but a number were indicted. And the DOJ, in announcing the indictments, actually praised the CFTC's invaluable assistance with respect to the investigations. That, among other things, became the basis for a motion by the defendants to seek discovery of certain materials, investigative materials of the CFTC. And Glenn, I'm going to turn it over to you.
So Matt, in particular, what you had is you had Bases and Pacilio, who were charged by DOJ, but interestingly, were not charged by the CFTC, or CFTC didn't take action against them. And of the 8 people who were charged on the same day by DOJ, they were the only 2 who didn't have CFTC actions against them. And so what they were doing in the litigation, the DOJ cases, Bases and Pacilio tried to get access to any information that the CFTC had that might be helpful for them in the case. And so, setting aside some of the procedural history, basically what happened is the judge ruled on a motion to compel discovery by Bases and Pacilio from the CFTC sort of via DOJ. And they did that under Rule 16, which is the discovery rule in criminal procedure, which requires the government, upon request from the defendant, to produce documents or other items that are material to the defense and that are in the possession, custody, or control of the government. And then they asked also for Brady material. And Brady material, as many folks know, is exculpatory evidence that the government has an affirmative obligation to provide to defendants. And so here, the theory was that even though DOJ was the party in the case, in the criminal case, the defendants wanted the materials from the CFTC because in their view, the CFTC was part of the prosecution team given the linked nature of the investigation. So any of the materials that might fit under Rule 16 or Brady that the CFTC had should essentially be considered under the possession, custody, or control of the DOJ. And Matt, could you sort of go through a little bit of what are the factors that Judge Lee looked at in making his decision about whether to compel discovery per the defendant's motion?
Sure, thanks, Glenn. Whether Judge Lee in the order or more generally, we're really trying to home in here on the level of coordination. And so, take, for example, the sharing of documentation. That standing alone almost never will result in a joint investigation. Sharing of documents amongst authorities is relatively common and certainly part and parcel of parallel investigations. But where you start to, step beyond that a little bit, you have the sharing of documents. Maybe it's coupled with impressions or recommendations or follow-up actions from one agency to another agency. Maybe in addition to that, you have situations where depositions, witness interviews are attended by both DOJ as well as CFTC representatives. Maybe you have secundees of the CFTC at the DOJ. So basically, you really have a fusing together with respect to the investigation and that close coordination, which is something that shifts it from a parallel investigation, no additional Brady discovery obligation, to a joint investigation where Brady may kick in. Glenn, from your perspective and experience, any other factors that typically seem to be important?
You know, Matt, I think what really is key here is that it's the investigative phase, right, in which these parties are acting together. They are conducting interviews together. They might be coordinating on meetings with not necessarily just individual witnesses, but also with the companies. They may be extending the investigation broader to the actual banks or institutions, and they may be managing that together. There are phone calls that they could have together. There also might be not just the sharing of data, but a review of the data that gets sort of passed along from one agency to the other, even in the context of discovery requests or investigative requests, making sure that each agency is coordinating on what dates they want to look at certain trades for, what search terms they want the company to apply to communications for production during the course of the investigation. Those are sort of some of the finer tooth questions that a judge may look at in trying to determine whether or not there was a coordinated investigation. Different from coordinated prosecution, because ultimately the agencies can make different decisions about how they want to go, and that's exactly what we had here with the CFTC not taking action, but the DOJ taking action. And I think Judge Lee rightly separated those two issues out. And so, Matt, we have a conclusion here. We have the judge ordering DOJ to review materials to consider for production. But what kind of takeaways do we have here for our viewers?
Well, so I think, Glenn, is a clear takeaway for clients and defense counsel is be really, really mindful of the process early on. Who's participating? Representatives from which agencies? Are there secundee arrangements? What are their respective roles? When there are witness interviews, right? Who's showing up, again, for each agency? Document requests, correspondences, interrogatories, whatever the case may be. Just being mindful of that process and those signals that are being sent, which ultimately may come to fruition and be really important if there isn't a declination in connection with an investigation or a consent order and things go to trial. This certainly could be a significant issue. Glenn, from your perspective, any additional takeaways?
Sure, Matt. And I think sort of stepping back a bit is that if you're ever subject to a CFTC investigation, I think you have to be prepared, as we've seen is grown more common, for DOJ to potentially get involved, and not just sort of after the fact with the sharing of information, but DOJ to get involved during the course of the investigation. And what that means is you're going to want to have counsel, both in-house counsel and external counsel, that is comfortable dealing not just with the regulators, but also dealing with criminal prosecutors who have a slightly different approach to investigations and ultimately to resolutions.
Great points, Glenn. Okay, well, that concludes our second edition of the video series. Thanks very much for watching. We appreciate your time, and Glenn and I look forward to speaking with you next week. Thank you.